By the way, when you get this email, you have been given a gift. You have been given a chance to de-escalate the situation, Judge. Judge Kaczynski, however, did not want to limit their relationship to matters concerning MB's job.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So in the Supreme Court of Wisconsin, I have titled this the Making a Murderer Judge Gets Suspended. But this is actually the Making a Murderer. He is a judge, but he was a lawyer in the Making a Murderer case. And he has been suspended. This is in the Supreme Court of Wisconsin, the Honorable Leonard D. Kaczynski. And you just follow me on this one. It's one of those things where like it starts at 0 and quickly moves to 100, and you're just going to be blown away. We review a judicial conduct panel's finding of facts, conclusions of law, and recommendations for discipline for the Honorable Leonard D. Kaczynski, a former municipal judge for the Village of Fox Crossing Municipal Court. We conclude that Judge Kaczynski's judicial misconduct warrants a 3-year suspension of eligibility for the position of reserve municipal judge, commencing July 3rd, 2018, with the condition that before requesting an appointment by Chief Judge to serve as a reserve municipal judge, he must successfully petition this court to establish his fitness to serve in that capacity. Beginning in 1997, Judge Kaczynski served as a municipal judge for 21 years. First for the town of Menasha Municipal Court, and then for the Village of Fox Crossing. On July 3rd, 2018, this court, in the exercise of its superintending and administrative authority over courts of this state, issued an order prohibiting Judge Kaczynski from exercising the powers of a municipal court judge until further order of this court. Judge Kaczynski did not seek re-election in the 2019 spring election. Consequently, his term as the Village of Fox Crossing Municipal Judge expired April 30th, 2019. Judge Kaczynski's years of service would ordinarily render him eligible to serve as a reserve judge pursuant to Wisconsin statute. The Wisconsin Judicial Commission originally received an ethics complaint concerning Judge Kaczynski in June 2017. When the commission notified Judge Kaczynski that it was investigating allegations of possible misconduct a few weeks later, it advised him that he should scrupulously avoid retaliatory conduct or witness intimidation. There's some foreshadowing for you. Chekhov's gun, anyone? On April 4th, 2018, the Judicial Conduct Commission filed a formal complaint against Judge Kaczynski. The Judicial Commission's complaint alleged multiple violations of the Code of Judicial Conduct. After the initial complaint had been filed, this court referred the matter to the Chief Judge of the Court of Appeals, who appointed 3 members of the court to serve as the Judicial Conduct Panel. The commission called a number of employees of the Village of Fox Crossing as witnesses. Judge Kaczynski represented himself and testified at the hearing. The allegations of judicial misconduct in this matter fall under 3 headings, the one we're going to be talking about. Most of the allegations are misconduct related to Judge Kaczynski's interactions with MB, a full-time manager for the Village of Fox Crossing Municipal Court. Interactions with MB. The Village of Fox Crossing Municipal Court holds court sessions lasting 90 to 120 minutes approximately 3 times per month on Thursday evenings. There are only 2 individuals who work at the municipal court during the relevant time period. Judge Kaczynski held the part-time elected position as municipal court judge. MB was the full-time court manager whose position was supervised by Judge Kaczynski. The municipal court judge and the court manager share a small office in the Village of Fox Crossing Municipal Building. This is important. Small office. No dogs in the office to prevent this from occurring. Prior to the events at issue in this proceeding, when a different person was the court manager, Judge Kaczynski was physically in the municipal court offices on a very limited basis, usually only arriving shortly before court sessions were to begin and leaving shortly after the court sessions had ended. But following the retirement of the prior court manager, Judge Kaczynski hired MB as the court manager in the spring of 2016. At the beginning of MB's employment, she and Judge Kaczynski would have occasional conversations about their personal lives and developed a friendship. They also engaged in occasional joint activities outside of work, such as going on a few runs in September and October 2016 that Judge Kaczynski labeled the Judge K Challenge Runs. Even before MB was hired as the municipal court manager, she and Judge Kaczynski had been friends on Facebook. The interactions between Judge Kaczynski and MB became strained, beginning in March 2017 due to a couple of incidents that MB found concerning. First, in a public comment to a post on MB's Facebook page, Kaczynski stated that MB was on her second honeymoon at an undisclosed location. MB informed Judge Kaczynski that his comment had been incorrect and he apologized. When MB was back at work a few days later, he and a friend arrived at the municipal court offices while MB was out of the offices. Judge Kaczynski then hid behind a counter. When MB returned to the office, he popped up and shouted, "Roar!" which startled MB. During this visit, Judge Kaczynski was sufficiently loud and boisterous that his conduct disturbed nearby village employees. In addition, a selfie picture was taken during the visit. Following the visit, Judge Kaczynski sent MB an email in which he stated that he hoped his visit had made her day, and that the visit was something he was more than happy to do for my best friends. MB was disturbed by the conduct. Approximately 2 weeks later, Judge Kaczynski asked MB to be in additional pictures of them and the office courtroom. She declined. Having become concerned with Judge Kaczynski's conduct toward her, MB sent an email to the judge on April 18, 2017, in which she stated that it would help her focus on her job if they kept their relationship work-related. This, by the way, when you get this email, you have been given a gift. You have been given a chance to de-escalate the situation, Judge. You have been told there's a problem, it's going to be a real problem, so why don't you back off? And this was a gift to Judge Kaczynski. If Judge Kaczynski ever wondered if MB had any sort of care or feelings for him, she cared enough to send that email. Judge Kaczynski, however, did not want to limit their relationship to matters concerning MB's job. In an April 20th, 2017 email, he agreed to minimize discussion of non-business matters during business hours. He indicated that he wanted to continue having discussions about matters in their everyday personal lives. That same day, Judge Kaczynski sent 2 additional emails to MB. The first stated, among other things, that he really liked to stop by the office at least once a week. The second, sent later in the afternoon, indicated that Judge Kaczynski had stopped by the municipal court office that day and stated that it was nice to talk with you in person today. The very next day, Judge Kaczynski sent another email. He expressed that he had been upset because he sensed a problem in their relationship, but that when he stopped by the office the day before, it had been like old times. He continued that it is complicated because I am both the boss and a close friend. On Saturday, April 22nd, 2017, he sent another email stating that he would not bring in treats to the office except on birthdays because MB had expressed concern about having recently gained some weight while on a trip. Yeah. 3 days later, he told MB that he knew her mother had visited her house the preceding weekend because he had seen her mother's location as a nearby friend on Facebook. Judge Kaczynski testified at the evidentiary hearing that he had not intentionally sought this information, which had automatically appeared on his cell phone, and that he had told MB about it so that she could make her mother aware that her cell phone was broadcasting information about her location to others on Facebook. The disclosure of this information, however, was upsetting to MB. The Judicial Conduct Panel noted that MB became visibly upset while describing this event during the evidentiary hearing. That same day, Judge Kaczynski sent MB another email stating that he was always open to resuming the Judge K challenge runs if it fits in your schedule once a month or so. He continued that the exercise is good, but the personal rapport aspect of it is actually more important. Judge Kaczynski's emails and his disclosure about knowing the location of MB's mother upset MB sufficiently that they led her to lodge a complaint against Judge Kaczynski with the village's human rights manager, the village's human resource manager, Linda Malone. That name will come back up again, that's why I'm saying it. After the complaint, the village manager Jeffrey Sturgill, had a telephone conversation with Kaczynski in which he advised Kaczynski that MB was overwhelmed by his non-work communication. Sturgill believed that Judge Kaczynski agreed to change his behavior because he did not want to lose MB as an employee. Then Malone met with Judge Kaczynski and MB and explained that there were concerns. They worked up a number of guidelines, including that no personal information about colleagues would be shared on social media, that all phone and email communications would be related to business matters, and that Judge Kaczynski would limit his visits to the office to 1 time per week. And that's where it ended. And that's the end of that. Judge Kaczynski did change his behavior and never, ever, ever violated. And of course he did. Of course he violated it. The Judicial Conduct Panel found that at the conclusion of the meeting, it should have been clear to Judge Kaczynski that he was expected to limit his communications with MB to work-related matters. Judge Kaczynski, however, ignored the guidelines that had been developed. Indeed, his subsequent conduct indicated that he was upset as a result of the meeting and was determined to express his displeasure to MB and to reject any limitation on communications to work-related matters. If you would like to take this moment to get up and use the bathroom or something, this is only the beginning. On the following Monday, just 3 days after the meeting, Judge Kaczynski sent MB an email that began with personal information about what Judge Kaczynski had done over the weekend. Keep that one in, editor. On 3 occasions during that week, Judge Kaczynski came to the municipal court offices. He sat close to MB's desk, facing her. He did nothing except tap his pen and make cat noises. He did nothing except tap his pen and make cat noises for 45 minutes. Can you imagine this?
Well, that certainly makes me want to hang out with him more.
Your judge comes over, sits next to you. You've had this tense relationship moment with him, and he starts going, meow, meow, meow.
I need my support dog back.
Meow.
Nico, help.
And they don't describe the noises here, but like you can make cat noises very sexual if you wanted, you know, like you can make, I think maybe we should avoid the YouTube demonetization with my horny cat noises, but
Cats in heat.
During another visit, he told a story about a dog being abused and then repeated it. On Thursday of that same week, he sent an email to MB discussing their personal relationship that made it clear that he would not abide by any limitations. He claimed that some short general conversation about interpersonal difficulties is really work-related, as we have to get along well, as personal and professional friends, to do our best. He also referenced an evaluation of MB that he would be completing in the next week. Thursday, May 24th, 2017, he sent another email in which he inquired about having a party to celebrate his overcoming a medical problem that the two of them had discussed at the end of 2016. MB replied that they did not need to have a meeting about such a party, but Judge Kaczynski continued to ask for her input about such a party, including through an email sent to her home email account. In that same email, Kaczynski again brought up their personal relationship, acknowledged that it was strained, which concerned him. He asked if there was something either of them could do that would bring back the happy relationship that existed from May 2016 to March 2017. MB sent a response email that having Judge Kaczynski come into the office to discuss plans for this party puts me on the spot, which she did not want. This prompted a reply. In the reply, Judge Kaczynski acknowledged that he had made her uncomfortable and lamented the loss of their discussions of personal matters. Quote, I miss the short discussions we had on how our households functioned and other things that friends talk about. I hope I have not blown that forever. Early the next day, which was the Friday prior to Memorial Day, Judge Kaczynski sent another email stating that he had decided not to have the party, but suggesting that they and their families could have a get-together at some point over the summer. That same day, village manager Sturgill learned of Judge Kaczynski's ongoing attempts to initiate personal, non-work conversations with MB. Sturgill and the village's attorney had a telephone conversation with Judge Kaczynski and explained potential violations of the village's policy prohibiting harassment in the workplace, advised him of the need to maintain professional decorum at work, and told him to cease communicating with MB about personal matters. Judge Kaczynski sent MB an email over the ensuing weekend in which he stated that he wanted to hit the reset button. He claimed that it had not been clear to him that MB wished to avoid after-hours activities with him. He stated that he now understood, but he chastised MB for not telling him directly. He then expressed that he still believed discussion of personal matters was necessary. My main concern is that a work-only discussion policy should not preclude normal water cooler discussion of things like Packers, Badgers, child graduations, children having children, recent vacation adventures, etc. I need to know what you consider to be over the line. Walking on eggshells during what should be relaxed casual conversations is not good for productivity or mental health. Your ideas on this are welcome. He complained about the fact that MB had defriended him on Facebook, encouraged her to reverse that decision, and stated that he wanted to start over with new rules. He claimed that being able to view her personal Facebook page allowed him to know what was going on in her life that might impact her job performance, and avoided the need for him to ask her the usual question about how vacation or the weekend went. And of course, that was where everything stopped and everything went back to normal. And no, of course not. It got worse. When village manager Sturgill learned of Judge Kaczynski's email, he sent a letter pointing out that he had violated the village's direction not to discuss the personal relationship with MB, and reminding him that he was not to engage in any communications that went beyond work matters. Approximately 2 weeks later, Judge Kaczynski sent an email to MB entitled Rule Violation. Judge Kaczynski acknowledged that the email violated every principle we have talked about regarding office conduct the last few weeks, but that he was sending it anyway. The email continued, "Feel free to report me to HR. I feel spunky this morning." Judge Kaczynski's focus on his relationship with MB continued. On June 22nd, 2017, he sent another email suggesting that they have a beer or wine summit to discuss the relationship issue. He suggested this summit would be an occasion to end the strict restrictions on no work-related discussions and replace it with the use of respect and common sense. 2 days later, Judge Kaczynski sent yet another email to MB. This time, however, he sent it to her personal account because it involved some personal items and he wanted to keep it off a government computer. He sent another email the same day, which was entitled MB and Judge K Relationship Rules, effective 6/26/2017. Included in that email were a set of rules that Judge Kaczynski was imposing for specific categories of activities. For example, under the activity In Chambers Conversation, the rule stated as followed: to be work-related, however, can briefly discuss outside activities, weekend and vacation plans, when does not interfere with work activities, treats to be brought in only on birthdays. Under out of office and office hours activities, the rule stated Christmas only for exchange of gifts, initiation of other activities by MB only, Judge K challenge runs, wine on holidays, etc. The chart also, he made a chart, also had rules for activities labeled professional friendship and personal friendship. For the latter, the rules stated yes, but not besties, and subject to limits above. On June 26, 2017, Kaczynski sent an email to Human Resources Manager Malone, in which he claimed that the 7 incidents about which MB had complained were minor. Her unwillingness to accept his view of how their relationship should work would be detrimental to the municipal court office. His email stated that he preferred not to work with such a person any longer than possible. He suggested that Malone should advise MB to give a little bit on the work-only thing. If MB did not do so, he stated that the alternative for me is to exercise my authority to terminate her employment.
You have to be my friend or I'm going to fire you.
The email stated that Judge Kaczynski had communicated with other individuals about the municipal court manager position, discussed a possible termination date for MB, and stated that Judge Kaczynski had a plan for obtaining resumes and quickly hiring a replacement manager. On June 29, 2017, Judge Kaczynski sent another email to Malone stating that while he had not made a final decision on whether to fire MB, she had until 5 p.m. that day to decide if she accepted his list of rules regarding their professional and personal relationship. The Judicial Conduct Panel found that by these emails, Judge Kaczynski demonstrated that he believed he could terminate MB's employment for declining to have a low-level personal relationship with him. Later on, June 29, 2017, the village's attorney sent a letter to Judge Kaczynski in which the attorney informed Judge Kaczynski that his conduct towards MB was a continued pattern of violating the village's policy against harassment, and that his threats to terminate MB constituted retaliatory conduct, which, if carried out, would be a violation of law. To cease personal communications with MB, and to cease making threats to terminate her employment. The Judicial Conduct Panel found that it is hard to imagine how the message could have been more clear. Judge Kaczynski was putting the village at risk of a potential lawsuit for his own personal reasons. So of course, that was the spot where the judge finally realized that he's causing problems and he backed off, right? No. Rather than take the village attorney's letter to heart, Judge Kaczynski elevated his conduct. After receiving the letter, he posted to Facebook that the shit is not over. I might have an employee termination today, not mine. The Judicial Conduct Panel found that while the post did not explicitly name MB, the only conclusion a reader could draw was that MB was about to be fired because she was the only employee he supervised, either at the court or in his private law practice. Because that's also another thing, if you didn't know that, a lot of these municipal court judges are also allowed to practice law. Like they have their own business, and then they're also a municipal court judge. Yes, there are very strict conflict of interest rules about no overlap there, but they work as both at the same time, which is a little weird because you want the judge in the municipal court to be paying attention to all their cases. But, the village of Fox, whatever, probably doesn't have a million municipal court cases that require 40 hours of hearings a week. So, yeah, the judge is more or less a part-time judge. At 12:50 a.m. on Saturday, July 8th, that's a.m., Judge Kaczynski sent an email to Human Resources Manager Malone with a blind copy to MB. The email stated that Judge Kaczynski was unfriending Malone on Facebook. The email stated, "At least I told you directly, some cowards don't." The Judicial Conduct Panel found that the coward reference was directed towards MB. Kaczynski admitted in his answer to the Judicial Commission's complaint that this email had been spiteful in tone and that his conduct in sending the email had not exhibited patience, dignity, or courtesy. A particularly disturbing event occurred on July 17, 2017. While alone with MB in the municipal court office, Judge Kaczynski lunged over MB's desk, knocking items off of it. While he did so, he whispered to MB, "Are you afraid of me now?" This conduct frightened MB. The Judicial Conduct Panel found that this action was an attempt to intimidate MB into acquiescing in his fixation on a personal relationship with her. On July 20th, 2017, while the municipal court was in session, Judge Kaczynski told MB to cool your jets in a voice loud enough for Malone to hear it in the back of the courtroom. Later that same evening, Judge Kaczynski sent MB an email once again bringing up their relationship. The email said, in short, if you want to restore a happy workplace, the first step is to stand up on your own and not use the administration as a crutch. I can overlook what I consider poor judgment in handling the situation. I cannot tolerate a weakling unwilling to have free and open discussions with the boss or insubordination. As a result of Judge Kaczynski's ongoing actions, Village Manager Sturgill held another meeting on July 26, 2017 regarding the need to keep the relationship work-related. After that meeting, Judge Kaczynski went to the municipal court office, dropped a white flag he had fashioned from some office supplies on MB's desk and said, "Here you go, I surrender, you win." Judge Kaczynski, however, was far from ending his campaign. In an email, August 21st, 2017, to a local attorney, he falsely stated that MB was looking for new employment, and there was a personality conflict between the two of them, and that she was not facing imminent termination. On September 5th, Judge Kaczynski left on his desk a mock letter announcing his resignation, on which he wrote, "Refused to sign." The letter was left in a place where MB would see it. The Judicial Conduct Panel found that Judge Kaczynski did this as a subtle communication to MB about their ongoing conflict. October 27th, 2017, he wrote a letter to MB reprimanding her for forwarding to Village Manager Sturgill 2 emails Judge Kaczynski had written to her. The letter stated that she was required to discuss any concerns about the emails with him first, and that her forwarding of the emails to Sturgill had constituted going outside the chain of command without good reason. On November 2nd, 2017, in the presence of both MB and Human Resources Manager Malone, Kaczynski mentioned both Harvey Weinstein and Bill O'Reilly. He then stated loudly, "I don't do that crap, and you should get that through your thick head." The Judicial Conduct Panel found that the comment was directed to both of them. The next day after this outburst, Kaczynski sent a letter to MB stating that his October 27, 2017 letter of reprimand had been intended to be a teaching tool to catch your attention. He said, "By this time next week, some things are going to happen that will cause a lot of fire and fury at the municipal building. No, I am not resigning. Just be psychologically prepared. Have a good weekend." The Judicial Conduct Panel found that this was not related to the work of the municipal court. It found that the email, including the references to fire and fury, was so disturbing to MB that village officials contacted police, and the police chief interviewed Judge Kaczynski about the email, where Judge Kaczynski then giggled more than once in response to the chief's questions. On Saturday, November 25th, 2017, Kaczynski sent yet another email to MB, this one bearing the subject line, "Thanksgiving greeting." The email referenced a pre-Thanksgiving email in which Judge Kaczynski had wished MB and her family a happy holiday, although the prior email had not requested a reply. Judge Kaczynski scolded MB for ignoring him. The email said, "Will not spend the next 1.5 or 5.5 years working with someone who actively despises me. I have told you this many times. We are approaching the end of the line on this." In addition, the email discussed the ongoing Judicial Commission investigation. There was an allegation missing from the additional letters from the Judicial Commission. Please see attached. The attachment to the email was a picture of a kitchen sink. At the evidentiary hearing in this proceeding, Judge Kaczynski admitted that the email had been sarcastic in tone. The next day, Kaczynski dropped off a second reprimand letter to MB. This guy just doesn't quit. The letter reprimanded MB for allegedly making false statements that Judge Kaczynski was stalking or tracking her in her complaint to the human resource manager and village manager 6 months earlier. Ultimately, after reviewing a grievance MB filed about the reprimand letter, Judge Kaczynski directed that the letter be removed from MB's personnel file. On Saturday, December 23rd, 2017, Kaczynski wrote a third letter of reprimand to MB. The alleged basis for this reprimand was her refusal to acknowledge or return Christmas greetings by Judge Kaczynski and her failure to respond in a positive way to his efforts to improve workplace rapport. Judge Kaczynski also emailed the letter to MB's personal email account. He subsequently prepared a post to his Facebook page in which he used a sad face emoji and made the following comment. "Len Kaczynski is feeling sad. Few things are sadder than a coworker who refuses to return a Merry Christmas greeting out of spite. No, I think few things are sadder than a judge who is this upset about not having a low-level personal relationship with his assistant." The Judicial Conduct Panel found that it was clear to readers of this post that it was directed at MB, since she was his only co-worker/employee. A meeting was held December 28th, 2017 that involved Police Captain Peter DeBoer, Judge Kaczynski, MB. During the meeting, Judge Kaczynski disclosed detailed information about where MB, her parents, her brother, and her sister lived, as well as who was the sister's employer and where that employer was located. Although disclosure of this personal information was obviously upsetting to MB, Judge Kaczynski continued to discuss the detailed information. The Judicial Conduct Panel found that a reasonable person would have understood Judge Kaczynski's disclosures to be threatening and offensive, and that MB in fact perceived them to be an effort to upset and intimidate her. In an email sent approximately 1 week later, Judge Kaczynski disclosed additional personal details about the value of MB's home and the nature of the financing she had obtained to purchase it. The panel found that there was nothing work-related about such information. On January 14th, 2018, Kaczynski sent a letter to MB that he labeled Letter of Counseling, Failure to Obey Lawful Order. In the letter, Judge Kaczynski recounted that he had asked MB to forward to him information she might receive about a farewell luncheon or party for 2 departing village police officers. The letter said that this had been a lawful order and that her failure to forward the requested information to him had been disrespectful. Judge Kaczynski's continuing conduct towards MB about what he viewed as a failure to maintain a personal relationship led her to file a petition seeking a harassment injunction. A Winnebago County Court Commissioner considered the petition and granted a temporary injunction on February 15th, 2018. The court commissioner's oral ruling stated that all communication moving forward should be work-related and essential to the functioning of the Village of Fox Crossing Municipal Court. Judge Kaczynski's emails to MB continued, despite the injunction. On the same day that the temporary injunction was issued, which was a Thursday on which a court session was to be held in the evening, Judge Kaczynski sent an email to MB indicating that he wanted her to observe him in a closed setting prior to the court session to see if he showed any signs of impairment. Such observation was not part of MB's job. Because she was not trained to make such assessments, she refused Judge Kaczynski's directive or request. 2 weeks later, Judge Kaczynski sent an email to MB with a link to a newspaper article about a dispute between a circuit court judge and a clerk in another county. Referencing that dispute, he said it could be worse. In June 2018, a Winnebago County Circuit judge conducted a de novo or brand new review of the temporary injunction. It affirmed the harassment injunction and extended it through May 1st, 2019. The written injunction order directed Judge Kaczynski to cease harassment of MB, to have no contact with her outside of work, to have no contact with MB's family members. The written injunction further specified that all communications between respondent and petitioner shall be limited to what is necessary to perform the functions of the Village of Fox Crossing Municipal Court. It further explained that, quote, communications related to the personal relationship or personal rapport between respondent and petitioner are not included in the operation of the court and are prohibited under this section. This permanent injunction did not cause Judge Kaczynski to cease his inappropriate communications with MB. Over a weekend, less than 2 weeks after the permanent injunction was entered, Judge Kaczynski left a color poster on his desk where MB would see it. The poster had a picture of the village manager's face with the following accompanying caption: I am from the government and I am here to help you. WWRD, #NotMeToo. At some point over the same weekend, Kaczynski posted on his desk, facing MB's desk, a copy of a page from the village's personnel policy manual entitled Sexual Harassment. On that page, Kaczynski had highlighted the word sexual 7 times in yellow marker. When MB arrived at work the following Monday, she observed both the poster and the copy of the harassment policy. She believed that the two documents violated the terms of the harassment injunction. Either she or another village employee contacted police, who arrested Judge Kaczynski. On July 11th, 2018, the state filed criminal complaint charges against Judge Kaczynski. The complaint charged him with 1 count of felony stalking and 2 misdemeanor counts of violating the harassment injunction. Shortly before trial in the criminal case, the district attorney's office dropped the 2 misdemeanor counts, leaving only the felony counts. The case proceeded to trial solely on the felony charge. Judge Kaczynski was found not guilty. Based on these facts, the Judicial Conduct Panel concluded that Judge Kaczynski had violated the rules of professional conduct in a number of ways. Supreme Court Rule 60.2 requires that a judge in every aspect of judicial behavior shall participate in establishing, maintaining, and enforcing high standards of conduct and shall personally observe those standards. Supreme Court Rule 60.03 requires that a judge shall act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. The comment to that rule recognizes that public confidence in the judiciary is eroded by irresponsible or improper conduct of judges, and that a judge must avoid impropriety and the appearance of impropriety. They then go through pretty much the facts that we just went through, but specifically the ones that violate each rule. And then they say, the panel further concluded that the conduct was willful. It therefore ruled that these violations constituted judicial misconduct pursuant to Wisconsin statutes. While his misconduct did not involve the performance of his judicial duties in the courtroom, it did occur in the context of the operation of the court over which he had been elected to preside. Although he claims that he was merely attempting to foster an environment that would be best for the operation of the court, it is clear from his actions that he was intent on forcing MB, his subordinate, to comply with his personal desire that MB should also be his personal friend, someone who would discuss life experiences with him, engage in activities that he favored, and conform to what he viewed as a proper friend etiquette, such as exchanging holiday greetings. Even if his intentions had been to benefit the municipal court, the effect of his behavior was the opposite. His actions, which cannot be dismissed as merely odd or quirky, caused real harm both to the particular staff member by causing her fear, discomfort, and considerable stress, and to the effective operation and public standing of the municipal court. His actions also negatively affected the village as a whole, which had to mediate between him and MB, a village employee. In the end, we agree with the Judicial Conduct Panel that, in light of the fact that Kaczynski is no longer an active municipal court judge, an appropriate form of discipline for his misconduct would be to suspend his eligibility to serve as a reserve municipal judge. In light of our July 3rd, 2018 superintending order prohibiting Judge Kaczynski from exercising the powers of a municipal judge, we make the suspension retroactive to the date of that order. In addition, because Judge Kaczynski's misconduct demonstrates that he currently lacks the judicial temperament and the insight into his actions that are required for a judge to preside over and manage a court, we also require him to petition this court and successfully demonstrate to us that he is fit to serve as a reserve municipal judge before he may request an appointment to serve as a reserve municipal judge from the chief judge of the applicable judicial district. Judge Kaczynski may not file such a petition in this court until the 3-year period of his suspension has expired. The chief judge of the applicable judicial administrative district would still have discretion under Wisconsin law regarding whether to appoint him as said reserve municipal judge. It is ordered that Leonard D. Kaczynski is suspended from eligibility for appointment as a reserve municipal judge for a period of 3 years commencing or starting July 3rd, 2018. It is further ordered that before he may request appointment as a reserve municipal judge by the chief judge of the applicable judicial administrative district, he must first file a petition with this court and demonstrate through appropriate evidence his fitness to serve as a reserve municipal court judge. And that's it. There's no further anything from that court. What do you think of that cluster? That was just absolutely amazing. It just keeps going and going, and every time you think, okay, well, this guy's gonna learn his lesson, he doubles down. Like 4, 5, 6 times he had a chance to stop there.
That was the creepiest story we've ever done on the channel.
Yeah.
That was really, really creepy, right?
And it very much is like the sum of everything. So like any one individual encounter is probably not enough, but it's the repetitive sum of everything where it's like, okay, so he's not allowed to talk to her about certain things, so instead he'll just leave posters on his desk.
Yeah.
Where, stuff like that, where he's like trying to get around and circumvent these rules rather than honoring the spirit of it.
He was very much acting like a child.
Yeah, that exactly. The last time I acted like that was when I was an actual child. When I was an actual child, and then maybe there were some adult temper tantrums in my early 20s as I was maturing. People don't mature until they're like mid-20s emotionally, and I probably was a year or two behind that anyway. So I definitely had I annoyed some people. I don't think I've ever reached the level of like harassment or anything, but wow, this is like that level. This is like a child who doesn't know when to stop, and this man is a elected municipal court judge, so shouldn't be, and he's not.
I think it's important to point out that there was a criminal charge that he was acquitted of, but the ethical and professional standards are different than a criminal standard. So he's not being denied this because there was a criminal conviction. He's being reprimanded because all of the activities that led up to the justification for the charge, they're inappropriate all on their own as a judge's ethical rules.
And that district attorney did that judge a huge favor, possibly even an unethical favor, depending upon your perspective. But so hear me out here. If the district attorney wanted the judge to get off of the charges, but also did not want to drop all the charges because that might look really bad, you then levy only the most difficult charge to prove, the highest level charge, the felony harassment or felony stalking charge, and you drop the lower ones, and then the jury doesn't have anything to fall back on. The jury can't say, oh, well, it wasn't the worst level of harassment, it was the lightest level of harassment. Without those light level of harassment, the jury doesn't have anything to fall back on and say that it didn't reach the level of really bad harassment, but it did reach the level of some kind of harassment. So the district attorney took that choice away from the jury, and I think the jury would have been able to find that there was some kind of harassment in violation of the injunction.
And I think at the beginning, people in chat had some sympathy, had some empathy with the judge, because he's acting kind of clueless, right? And he's done something and he's hurt his friendship and he wants to repair the friendship. And I think, like, my heart goes out to him a little bit at the beginning. But when someone sets those boundaries, repeatedly crossing the boundaries over and over again does not make someone want to be friends with you. It does not repair your friendship when people set boundaries and you're like, no, I'm going to pretend that you don't have them. Like, that's an issue.
Plus, I mean, this is like a judge. You expect them to be well educated and knowing about like how to lawfully do things, and the things he done is very much questionable.
That woman deserves a medal, by the way. I don't know how she stood up that long against all that stuff.
I don't know how
was
she
able to
still
keep going.
I don't know how she managed to still work there, not that just ended up just trying to find a new job to get away from him.
Yeah. I mean,
Look, it lasted for years.
that lasted for better part of a year, if not over a year. Yeah, that started. He hired her middle of 2016, and then like the tone changed March 2017, and then he wasn't arrested or whatever until 2018.
It was mid to late 2018, wasn't it? Like
how long was this
September
going
or
on?
August.
Yeah, so this was from March 2017 to mid 2018, I believe.
Ooh.
So I think that she's probably got some kind of claim. And she's probably a saint, if you ask me, for not bringing a claim against the city. Because the village obviously was trying to make this better. So I don't know that reasonable people could disagree as to whether it would be the right thing to do to bring a complaint against the village. But holy mackerel, she should sue the crap out of or obtain a settlement from the former judge, because she's definitely owed something for her pain and suffering with that guy, in my opinion. I don't know Wisconsin law. I'm not trying to give anybody legal advice. I'm not a Wisconsin attorney. Don't take this too far. I'm just saying, in my opinion, I think that she's entitled to something from the judge, at least. Something more than a personal relationship. Money. So that's our show for today. We are going to hold a Wednesday evening stream, probably like a 7 p.m. Eastern time or 6 p.m. Eastern time kind of thing. Let us know what you think of our stories and things in the chat and in the comments below. Thank you for joining me today, everyone. I am Leonard French, your favorite copyright attorney. Thank you to our patreon.com/ljfrench and sponsors.org/law supporters who support us financially and make these stories possible. Thank you to Joshua Davis, who is supporting us in July at the $500 level. We're going to make a video for Joshua about the TandaPay service that he has developed. It is a social insurance program that is based on the blockchain, and we're going to see what's super interesting about this. Thank you very much to our $50 plus supporters, Jonathan Steele, Gavin Barnard, Kyle Mudrak, Eevi, I almost said Andy,
Yeah.
Michael Pearce, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky. Thank you very much for your support at the $50 level, and thank you to the $5 plus supporters, including Joe Tyson, who I forgot about, so I'm making it up to him, who are scrolling on the LED panel behind me and will be in the description of the videos that drop. I'm Leonard French, your favorite copyright attorney. This has been Kaylee with us here in the studio. Brandon and Tactical and Kurt Mueller have been in the virtual studio. Thank you very much for joining us there. I'll leave some room here for the editor to put some dog video, but here is also a dog for you. Hup. Good boy. Good boy, that's my dog. This is Nico. Nico has also been in the studio today. Up. And I hear an Ilsa. I hear an Ilsa.
Ilsa.
Do we have an Ilsa coming over? She's gonna give Kaylee her butt because Ilsa likes her butt rubbed. But which dog doesn't like her? And she's a black dog. She's a dark dog, so you can't see her on the camera. That's great. You are the nicest dog. You are the nicest dog ever. Love you all. Bye.